It's a huge pleasure, though, each year to come together for the Genest lecture, and it really is a time both to mark the arrival of an important guest who's going to help shape a number of discussions around the law school, not just today and in this talk, but also a time to reflect on the Genest family and friends and their generosity in establishing the fund that allows these visits to happen. And we are really fortunate today to have Pierre Genest's son and daughter-in-law, Paul and Barbara, with us. And it's something that we see as very much an ongoing relationship and one that really becomes a family affair for us as a result. So especially on a day when, as we say, we separate the fair weather friends from the true aficionados at York University, to have you guys up is quite special. I can also assure you that the university is going to forge ahead and remain open and active for this talk. Afterwards, I think the leadership got together and said really what's going on that's worth it once Peter's spoken, so it may be the case that the university closes shortly after we're done, I think around 2:30, but we are fine and enjoying, I guess, the wintry splendor from a distance that we see out the windows. So the Pierre Genest Memorial Fund, again, for those who aren't here every year and don't have the opportunity to hear something about it, was a fund established in honor of Pierre Genest. It creates a global faculty of visitors who come. Some do workshops for credit, some do a series of guest lectures, some do mentorship with our graduate students and scholars, some do combinations of all of those. And the themes typically involve comparative law, constitutional law, something about Canada's federal, bijural, bilingual, bicultural, multicultural connections and traditions. And this creates a really vibrant linkage that is always timely. And we had the good fortune over lunch a bit earlier to remind Peter of all the live debates that intersect with these topics going on in Canada right now. And of course, to benefit from things that are happening elsewhere as part of our conversation is going to be a clear goal of the Genest program. So Pierre Genest was one of the leading litigators in the country, but really that's not why this fund was created. It was being that kind of Renaissance lawyer who really did engage in intellectual, philosophical, policy and political debates as much as the system of justice and the administration of justice is what characterized Pierre Genest, and I think what inspired those who cared for him to come together to create this living and lasting legacy. So that's very much what brings us together. And what brings us today together is Peter Fitzpatrick, who has a series of titles that are hard to forget. So he is the anniversary professor of law at Birkbeck in the University of London, as well as an honorary professor of law in the University of Kent. And to anyone who looks at questions in law and society about law as resistance or the Foucauldian tradition of seeing a legal analysis through a lens of broader dynamics of power, authority, freedom, liberty, you will already have come across Peter's work. And if you haven't, there's links to some of his books and scholarly contributions that are easily available. We were hearing as well that sense of spawning a whole generation of people who look at law and society differently through many graduate supervisions and many connections to emerging scholars. And Peter is that kind of mentor to people who, again, some end up in law schools, some in great law and society departments like the one here at York, and it's great to see colleagues from across the university, not just the law school, here today. But it's fair to say that this is shaping a really important interdisciplinary and a comparative set of debates. So I won't go into other roles Peter's had as visiting lecturers and in policy, particularly in Papua New Guinea we were just speaking about. But suffice it to say there are important stories to be told, I'm sure, from each of those stints, and we'll hear at least a slice of current thinking from Professor Fitzpatrick today. So please join me in giving a warm Genest and Osgood welcome to our guest speaker.
Thank you. Well, thank you, Mr. Dean, for that sustaining introduction and the sustaining lunch as well. Well, thank you for being here. I mean, and congratulations. If anything remotely like this happened in England, I'd be talking to an empty hall. It's staggering.
We're Canadian.
Yes. I'm honoured to be offering a lecture associated with Pierre Genest for the reasons that have just been given. And I'm also honoured to have Barbara Jessup and Paul Genest in the audience. And going on the range of Paul's academic engagements and achievements, it might be more appropriate if he was up here and I was down there, but I think I'm stuck with this one. And I'm honoured to be back at Osgood, actually. This is my fourth invitation to be here. I won't tell you how long it stretches back. And I'd like to think that it was an example of the Mae West principle, that you can't have too much of a good thing. But I suspect it's more a matter of, let's see if he gets it right this time. We'll give him one more go at it. If that were the case, I came across this lovely bit of Beckett the other day, and this could be the epigraph for it: try again, fail better. And if I don't fail better, it wouldn't be for the want of the wonderful support and concern that I've had from Jodie Ann Rowe Butler and Professor Ruth Buchanan. Ruth is for me the exemplary, I'm going to embarrass her now, the exemplary academic with her abundant intellectual imagination and creative generosity. She also sort of got me into this mess, I believe, and she also obliquely gave me the concern for this lecture, because I was busily working away on something doubtless quite arcane. I think we were talking on the phone, and she indicated to me that Osgood was still, pretty well up there as far as law and society goes. So I thought, oh my God, I'd better say something about law and society and resurrect an old interest and see if I can relate it to what I've been doing since. And that's what I've tried. That's what I've tried to do. More specifically, I think we might ask whether, in late modernity, there are perspectives that are emerging in philosophy, perhaps in particular, that might throw some light on and provide some rather intriguing paths beyond the concern with the connection between law and philosophy. But first of all, just a note on the title, Strange Gods. The more usual version where this would come from in the Decalogue is, I am the Lord thy God, thou shalt have no other gods before me. But the Douay version is no strange gods before me. And I hope you'll appreciate why I prefer strange as we go along. Okay, so something like an abstract for the talk could go something like this. The still burgeoning field of law and society presents us with, still, I think, two seemingly disparate notions of law. With one of them, law is the abject creature of society, if you like, or of some social force that tends to dominate society and dominate law, and economy is usually a leading contender. The other dimension has law assuming some kind of independence, some kind of autonomy, and being able itself to act upon society, to, as the terminology so often has it, to shape society, even in times to create society. So what I want to say is an analysis of society in its modern and late modern terms shows us that both these meanings, if you like, of law are there, and that they are, strange to say, I'm just pitching this too highly, I think, but I've got to go on now. That's strange to say that they're compatible with each other. And that's true, I think, yes, what I'm going to try and argue. But what I also want to argue is to say that compatibility points us towards notions of sociality and the relation between law and sociality that go beyond this existing terms in which we engage with law and society. Now, that as an abstract would be a rather abstract. And so I'll try and situate things rather more explicitly by looking at Foucault and the lectures on the birth to biopolitics, which are quite remarkable, I think, with the position that he places society in relation to what we could broadly call other social forces. As you know, is too well known, I suppose, these days, Foucault perceived notions of governmentality, his horrible neologism, or biopolitics, the ordering, the ruling, in a sense, the tentacular ruling of whole populations across the whole range, tied integrally with notions, and this was his earlier work, with notions of discipline and so on. You have a pervasive and a tentacular governing of whole populations. For Foucault, society, as it were, serves that kind of function by being an instrumental adjunct, if you like, of that type of power. Just to quote from the lectures on the birth of biopolitics, we're talking about an omnipresent government, a government which nothing escapes, a government which conforms to the rules of right. Well, that's an interesting reservation for now, but we'll come back to it. And a government which nevertheless respects the specificity of the economy, and a government that manages civil society, the nation society, the social. But this management of civil society is not a complete domination, because he then goes on to say that it's the very notion of civil society that enables this another horrible word, governability of individuals. Also, just trying to complete the picture and moving on to economy, we find a similar seeming contradiction, that the economy for Foucault is something in liberal and neoliberal dispensations, which is what he's dealing with here, is something that is uncontainable. It's treated as a kind of natural thing that's just there. And it can't be, and somewhat like governmentality, its range is illimitable. At the same time, and hence, society again, as civil society in particular, comes to the aid of notions of economy, which given its range can't be, of course, encompassed by any notion of society or any determinate or limited notion at all. But then he goes on to say that society provides the field of reference within which this is made possible, in which there's a governing which combines governing economically and governing juridically. So we have a bit of a mess, but it's one, I think, where we have this fascinating conjunction and disjunction between these various elements, say governmentality for brevity's sake, and economy on the one side and society on the other, where society is both a kind of a subjective instrument of these forces, and because it is serving an illimitable boss, if you like, that society itself has to be illimitable if it's going to perform that function. In a sense, that very illimitability sets it apart as well, because it in turn can't be contained in any terms that are going, and hence, even as a vacuity, even in its abject state, it provides these field of reference, as he calls it, and these modes for these other things to operate. Now, this division in society, I mean, I'll come back to that conglomerate later because I'll be relying on it as my kind of case, if you like. But this notion of society is, I think, fairly conventional, actually, in some ways, but that doesn't mean to say that it's not right in some ways. If we look at Raymond Williams' keywords and the wonderful, abbreviated synoptic genealogies he has of various things there, if we look at society, he would say that, and in a way which remarkably parallels Foucault's history of this, actually. People slag Foucault off routinely for his bad history, but he seems to get it right on this occasion. Raymond Williams sees society divided between what he calls an active and immediate sense, and society as, in a general and abstract sense. And on cue with Foucault, he notes that from the 18th century, the abstract and general sense strengthens, as he puts it, until today we see that it's pervasively dominant, and that it somehow subordinates the other sense, and in a sense almost displaces it as an operative factor. In a like vein, Lefort traces the emergence of modern societies, the existence of which can no longer rely on a transcendent reference beyond them, and finds in modernity a society that is self-sufficient in being, as he puts it, transparent to itself. It's intelligible in itself. Then he makes a remarkable claim, which I think is spot on. He says, an illusion which lies at the heart of modern society, he refers to this, namely that the institution of the social can account for itself. There are also many more in the social sciences, many more straightforward declamations which pitch the scene on one side of the other. On one side of the divide, you have society comprehensively subordinated to some other force, usually economy, and being the abject creation of this other force. On the other side of the divide, you have society, as in Lefort's terms, able to account for itself and rampantly creating, constructing, forming everything around it, including our very identities. And notions of social constructionism in sociology, for example, would illustrate this. Now, this leaves society seemingly mired in existential incoherence. And I'm suggesting, no more than suggesting, I'm saying that a resolution of a kind can be found if we go to Nietzsche. I want you to know it was a very responsible lunch. Paul and I were discussing Nietzsche at some length. So Nietzsche and Nietzsche's supremely sane madman in the death of in the Gay Science, where the madman enters the marketplace and announces to the uncomprehending moderns that God is dead. He doesn't get exactly an engaged response, and realizes that they do not realize that this has happened. It's an event, says Nietzsche, says the madman, says Nietzsche, that is still beyond us. It's still to come. It's still on its way. And he asks, what in the hell, he doesn't quite say that, but what in the hell we're going to do about this? And he concludes that we're going to have to invent what he calls sacred games, or what he calls festivals of atonement. And I looked up atonement in my very old etymological dictionary, and so I don't know whether this is still valid, but it's rather lovely. You've got at, one, and meant. In other words, the return to a unity. So festivals of atonement we no longer have that unifying force of this transcendent reference, this God. So we have to invent other sacred games or festivals of atonement to restore our own unified being, if you like. Nietzsche's favorite sacred game, and this is in Zarathustra mainly, is the state, the modern state. He calls it a new idol, and he compares it to the ordaining finger of God. And that, although he irresponsibly doesn't footnote it, is from Exodus. The assumption, as with society, has the state fusing the illimitable, this range of illimitable force and power that was characterized with the deity and with transcendent reference, has it fusing it within the determinately existent. So that the modern nation state, providing the typical example for Nietzsche, is, as so many people in sociology have noted, most often equated and really confined in its determinate guise to the society of the nation. That's the paradigm that tends to be adopted. And of course this drags in all sorts of notions like sovereignty and so on, the dragging in of the immensity, the unencompassable immensity of the sovereign claim, which is unlimited, into a specific locale, whether you see it as the state or whether you see it as society, involves the drawing in of the transcendent to a determinate location. That inexorably ramps that location itself up to a transcendent domain. And the competence that both society and the state take on is of a markedly monotheistic kind. It's a very uncomfortable monotheism because these deific substitutes are not singular. There are several of them, but so far I've just touched on the nation state and the notion of society. This, of course, leaves a considerable problem for the modern, because if you are going to adopt and resort to some kind of transcendent reference, but you're supposed to be living in a secular world, and I'll say a bit more about that in a minute, then how do you reconcile those two things? Because secularism is not capable or rejects the notion of a transcendent reference. What I'd like to suggest is that this is effected, or this is the next solution that comes onto the table, by something we could call a negative universal reference, which goes to constitute an Occidental modernity. The reference in absorbing Nietzsche's infinite nothing, because that's what the madman sees. He sees us cast now into an infinite nothing, something which Hegel, for example, had already perceived. That, in a sense, by adopting a negative reference, avoids referring to some kind of unmodern, transcendent positivity. And I just want to say a bit more about that before, but first of all, I just want to slip in Heidegger's commentary on Nietzsche's parable, which situates this nicely, I think. Heidegger puts it this way: even if God has vanished from his place in the supersensory world, still the place itself is preserved, although it has become empty. The empty place even invites its own reoccupation and calls for the God who disappeared from it to be replaced by another. Hence I'm moving towards my strange gods gradually. Okay. So such another, whether nation state or society, becomes what certain alterities, certain others are not, or it becomes not what they are. I suppose in ways one could say the original instance of this in modernity is the invention of racism in the 18th century, late 18th century, where the claim to this negative reference, being universal, has to reject the other against which it's constituted utterly, completely, because anything that's beyond the universal can only be utterly or completely beyond it. But at the same time, and this is the neatness of the beast, at the same time, the universal has to extend to and incorporate, in a sense, that which it has just rejected. So the excluded are also bidden to, I hope that's not urgent government business, the excluded have also to be brought within the domain of the reference, as well as excluded from it. So here we could turn briefly to Foucault on governmentality and biopower, and disciplinary power as well. A type of conjunction, disciplinary power, as he puts it, encompassing the very life of society and the lives of its members. And Foucault, in a trajectory that emanated from racism, and I take this mainly from his Society Must Be Defended, he says racial division provided the first historico-political discourse on society. I don't know whether that's so really, but it suits me, so I'm just going to stick with that for the time being anyway. The first historico-political discourse on society, but he brilliantly, in that set of lectures, merges that into his consideration of biopower and disciplinary power and notions of the abnormal and the anomaly, and the way in which these types of scientific operation of power in modern society operate by way of negation. Although that's associated with his later work, he really did the same thing in Histoire de la Folie, because he was saying there that we only know sanity through insanity. And he spends a very big book saying that. And I know it's contested, but he then returns to that theme without linking it with insanity, actually, and ties it into these disciplinary formations and into biopower. So the formative force of the socially normal and the socially conforming looks to what is other to it. It's a negative reference. The abnormal and such, says Foucault, are both interior and foreign, subjected, as he says, to an inclusion through exclusion. Okay, now, all of that might seem to take matters no further than society simply being part of the conglomerate of power mapped by Foucault, society as a functional extension of governmentality, biopower as a functional extension of economy, and so on. Yet, as I tried to indicate, there is another society, if you like, lurking within that conglomerate, which seems to take on, through its very illimitability in its functional role, some kind of independent existence otherwise. That society itself also forms through a negative universal reference. This is something that's come up quite dramatically recently with work by the medievalists and the people concerned with periodization, who are saying, look, we've had enough of this dark Middle Ages stuff and all the rest of it. Although our Prime Minister in the UK hasn't, every Prime Minister's question time, he managed to squeeze in a reference to the dark Middle Ages by saying, if you actually look at these things, it was never anything like that. Feudalism was an invention of the 19th century, so on and so forth. It's a much longer story, of course. But nonetheless, what's being traced here is the formation of society as modern by way of a rejection of what came before it, an encapsulation and a rejection of what came before it, and by the rejection in a like mode of barbaric or savage societies excluded from a universalized civility. This is the supposed outcome, in terms of the standard trajectories that we find, of a progressive development of society. More specifically, as Frisby and Sayer put it, the concrete development of Bürgerliche Gesellschaft, market society, civil society, bourgeois society, only then, and this harks back to Raymond Williams' terminology, only then did the generality society become visible. This generality coinciding with Williams' general and abstract sense, society in terms of its pervasive dominance over the active and immediate senses. And it's this negative universal reference that frees the abstract and the general from a positive type of constraint. So you can make illimitable claims for society, along with Lefort, for sovereign societies, for national societies, without having the constraint of a positive reference spoiling the fun and actively constricting you. So, this is supposed to be about law and society, okay. So, look, I'm going to do it. Law and Society 1. This is the longer one. So, looking, and I'm not too sure about this because I'm a bit out of date, but so, and this is why I'm here. I want to steal stuff and I want you to correct me. Law is appropriated in this scheme, say in Foucault's conglomerate and all the rest of it, but it has a very specific prominence in the process. In the field of law and society, law is often conceived of as entirely dependent, as some kind of entirely dependent offspring of society, or, as I've said earlier on, of some pervasive force. And so much so that when certain types of society are seen to be rampant or predominant, such as regulatory society, the administered world of Adorno and all the rest of it, we find statements about the death of law, that somehow this scheme of things is incompatible with the existence of law. This is what Foucault gets saddled with, wrongly, utterly wrongly, that the pervasion of disciplinary society, biopower and so on, means that law no longer has any, as it were, autonomous or coherent function or being of its own. Yet, by way of partial relief, a persistent strand would say that the law has a relative autonomy in relation to society. That used to be pretty fashionable, I seem to remember. So it has some distinctness and efficacy, even if not a great deal. On the other hand, as it were, there seems to be an imperative for society itself to generate an autonomy of law, which is recognized in the literature. So with the type of modern society inhabiting my argument here, law arrives at a position of quite differentiated autonomy. We're talking here about, as Foucault's concern in biopolitics, with liberal or neoliberal society, where law provides the link between society's now disparate members. Some fairly famous instances of this. Donald Black, in the midst of strangers, law reaches its highest level. Or Stanley Diamond, the progress of law consists in the destruction of every natural tie in a continued process of separation and isolation. And there's actually one more statement which I threw out because I wasn't sure whether it was quite right, but I think it is now. Michelet, law is more reliable than all our forgetful loves, our tears so quickly dried. I think it's relevant there as well. Okay. Also, intriguingly, but again, this is harking way back, Pashukanis, in the 70s, I guess, when he was all the rage, where you have the commodity form and the relation of the commodity form actually requiring and forming law as a kind of independent entity. So coming to the final furrow then in this field of law and society, I've already ploughed a few. Law's established distinctness is heightened, or even as it remains formatively tied to society, by a remarkable little book, I think first came out in the 1970s, second edition about 20 years later. And I don't think it's really has had a lot of attention. It's had some. Nonnett and Selznick's Towards Responsive Law, Law and Society in Transition, which is refreshingly brief. And they certainly pack a lot in. That's Toward Responsive Law, Law and Society in Transition. Now, they adopt what they call a social science approach, seems to be so, and they sketch what they call a development of three modalities of basic states of law in society. One is law as a servant of repressive power. Two is law as a differentiated institution capable of taming repression and protecting its own integrity. Now, I think for that they feel that law has to, as it were, defer in relation to the power that it claims for itself and adopt a fairly limited range of what it can, not entirely, but a fairly limited range of what it can and can't do. But finally, law as a facilitator of response to social needs and aspirations. And what is most distinctive for them about this topology and this is their ultimate concern, is a responsive legal order more open to social influence and more effective in dealing with social problems. And they talk about the Supreme Court in the United States doing that sort of thing these days and so on. They do say, however, that the danger of this is by being too responsive and absorbing too much in, you run the risk of dissipation and falling apart and not being very, very effective. So you have to have some kind of solidity or stolidity. I think, however, that they do miss a rather important dimension about responsiveness here, though. And I was reminded, and this is something I've inflicted on some of you yesterday, of Lampedusa's novel The Leopard, where at the time of the Risorgimento in Italy, the nephew of the very conservative count, who is very much against the Risorgimento and the liberal governmentality that the Italians are wanting to adopt, and he wants things to stay exactly the same. And Tancredi says to him, he says, well, if you want things to stay the same, everything is going to have to change. Which is beautiful, because if you want to hold on to something and keep it the same, somewhat paradoxically, you have to be able to adjust it continually to everything that would come to it and require it to be different. So responsiveness is not just pure responsiveness. Responsiveness is also in some way integrated with the imperative of continuity, determinacy, and so on as well. So it's a dynamic interaction. Now, they do recognize that in kind of schematic terms, because they do say that all institutions establish a conflict between integrity and openness, and they find a similar dilemma that occupies modern society that I sketched earlier, the dilemma that's involved in law being somehow determinate and apart, and the law that responds to other powers. But just to emphasize, just seemingly going back on what I've just said, this law nonetheless has to be utterly responsive. It has to be illimitable if it's going to serve, if you like, its very function, in crude terms, of serving an illimitable claim of society or sovereignty. That in itself requires of it that it be illimitable as well, and there has, in conjunction with it, to be a point apart from that illimitability where it can be brought together in specific determinations that we look to law to provide for us. So the disparity between the seeming disparity between those two things, I'm saying, matches the seeming disparity in the constitution of the social itself. The imperative to be both located in some determinate way, but utterly illimitably responsive in this abstract and general sense that Williams also emphasizes. My argument then would be that what impels the relation between law and modern society is the block that I referred to a while ago now on societies being able to resort to some kind of positive determination without more. Because the resort to positive determination counteracts or would reveal the reliance on the negative universal reference. There are various ways this has got around, but I'm confining it, obviously, to the relation to law. Law in relation to society, then, comes onto the scene to provide that positive, determinative reference which society itself cannot provide in an enforceable way, because this would be to assert a transcendent capacity in a positive sense, and that, of course, is most unmodern. So it's all coming together in a sense around this question of the relation between law and society. That society finds itself in a situation where it's constituted negatively, absorbing Nietzsche's infinite nothing. it finds itself in a situation where, if it were, and then it adopts, it gets around, that gets around its actual resort to a transcendent reference, that comes from its illimitability, its deific sweep, if you like, in terms of the claims that it will make for itself, and the ability to bring that into a situated scene which ramps society, or that particular society, up to a position of transcendence. You have a transcendent claim based in negativity. Law comes on the scene and provides the positive, enforceable reference, which helps, in a sense, society to get around that particular problem. It helps society get around that particular problem because law itself does not assume any enduring positivity. As Blanchet puts it, to law alone pure transcendence. Law continually vacates its existing content and assumes some other determinative form. And here I'm not just talking about the discrete or distinct legal decision, say in the courtroom or so on. This whole tension is played out in the very question of whether you can have a legal system, for example. The very question, which has plagued jurisprudence for ages about the unity of law. Our very ability to group law together in distinct fields or distinct areas depends upon the decision we make, in a sense, the formative decision we make in resolving that particular tension. And I think transnational law, which is pretty big here, I see, more or less fits that kind of scheme beautifully because it manages to be a community of communities of law, if you see what I mean. That the incredibly diverse elements or sites of occupation, if you like, that are the transnational laws that are brought into force can somehow connect and disconnect without any kind of sovereign affirmation. That dynamic is within law itself. Okay, now that's the end of Law and Society 1. One might then say that I haven't done anything more than refine the dependence of law, if you like, on some kind of society and just presented it in another guise. So I'd be aligning law with the type of modern society and saying, well, that's what it now does. But I now want to finally, and all too briefly, I'm afraid, make a rather stronger claim for law in its relation to society. And that is to say, a law that escapes what Nancy calls the already established, already stifling reign of society and can be seen as congruent with society in a less constrained sense. And this might seem a bit perverse, but I'm going to Rousseau to kick it off. In the social contract, so I'm looking at Paul again, I should be saying that in another language, shouldn't I? But anyway, I won't inflict my French on you. There's enough of that over lunch. He makes a remarkable assertion that law, in a sense, is exactly identifiable with society and in some sense precedes society, because he says, if we want to be what we are as a result of the social contract and make laws as a result of being in that social contract, being in society, being what he calls a people, and in some other location he calls a nation, if we want to do that, we would already have to be like that before we actually form the contract. Which doesn't sound very helpful, does it? But anyway. He then says, he fills in the gap, he says, by positing what he calls a lawgiver. And this lawgiver, and there's this wonderful phrase, he says, gods would be needed to give men laws, okay? And this lawgiver occupies that kind of a slot, the God slot, if that's not too irreverent, okay? The task that the lawgiver has to fulfill is beyond, he says, beyond human powers. But nonetheless, it's a task which he sees as imperative and necessary in the world. Now, the characteristics of this lawgiver are very interesting, I think. The lawgiver has to have no kind of material interest in the society. In terms of Raymond Williams' distinction, there can't be that kind of immediate relation to society in terms of its immediacy. It's very general and very abstract. In other words, the lawgiver has to be a kind of a vacuity that is completely open to possibility, to the determination of things ever otherwise. Quite apart from the people, but ultimately, of course, very much identifying in some way with the people when the laws are being brought to bear. And this lawgiver exhibits, according to Rousseau, a superior intelligence, has a great soul, and he goes on and on about it actually. But these attributes are but analogies for the dimension of law drained of attachment and to anything material and constantly attuned beyond the existent. Now, what I'd like to suggest is that there is an affinity, a bit of an evasive term, but anyway, an affinity between what Rousseau sees as law here and certain notions of law in relation to society, which we find inevitably, of course, in post-structural philosophy. And I'll just take a statement of Derrida's and a bit more of Derrida after that to bring that home, as it were, where he describes in Politics of Friendship what he calls a law of originary sociability. Now, I've read this so many times it seems coherent, but it mightn't be. Let's try. He says, this law of originary sociability he finds in the relation to the other, a relation prior, he says, to all organised socius, prior to all, and this is his emphasis, determined law, prior to all determined law, but not prior to law in general. Echo of Raymond Williams again, general notion of society. Not prior to law in general. This law, he says, of originary sociability being also a law, perhaps, he says, the very essence of law. Yeah. I think we can get a more situated sense of that law by looking at his engagement with hospitality and what he calls the law of hospitality. So if I can just run through that briefly. And this might raise more questions than it answers, but let me try. For Derrida, hospitality is unconditional, imperatively unconditional, and this is the way he puts it. Only an unconditional hospitality can give meaning and practical rationality to a concept of hospitality. Unconditional hospitality exceeds juridical, political, or economic calculation, but no thing and no one happens or arrives without it. We need this unconditional relation to alterity to the other in the ethos of hospitality for anything to happen, he's saying. Yet, a conditional or a conditioned hospitality is also, for Derrida, imperative, and this is the way he puts that. The unconditional law of hospitality needs the conditional laws. It requires them, he says. That's his emphasis again. He emphasizes a lot. It requires them. This demand is constitutive, he says. It wouldn't be effectively unconditional, the law, if it didn't have to become effective, concrete, determined. So we have hospitality, the law of hospitality, the law requiring both this utter unconditional responsiveness and a determinate affirmation. In sum, he says, political, juridical, and ethical responsibilities have their place, if they take place, only in this transaction between these two hospitalities, the unconditional and the conditional. So the two things are absolutely essential for each other, even as they have to remain, as it were, apart from each other. If the unconditional were allowed to run rampant, as it were, you'd have mere dissolution and dissipation. If the conditioned assume some kind of dominance, you'd have, say, the position in Lampedusa's The Leopard, where you'd have a stasis which would very soon cease to relate at all effectively to a world inexorably changing around it. As Derrida says, summarily, in their very heterogeneity, these two things are undissociable. In their very difference, they have to be, as it were, together. So returning to law and society then, we have a law that melds into both of the disparate strands which go to make up society. With one, there's a determinate law that is somehow apart from and impacts on society. With the other, we have a law that is intrinsically responsive and derivative from society. There's a continuate coming together inextricably of these two elements in and as legal determination. And as I suggested earlier on, determination not just in the particular decision, but in the very form and formation of what we take to be areas of law, areas of life and law, and legal systems. Some of these, of course, I'm not saying that everything's always changing and responsive and marvellous. Some particular determinations can last a very long time. For example, the nation has for too long provided the paradigm of the dominant notion of law. So much so that it was only fairly recently, in terms of jurisprudential thought, that things like international law were actually thought to be properly law in any way. Still struggling with that one. But that's because the model, elevated quite arbitrarily, Hart, for example, in the concept of law, just says right at the beginning, well, law is municipal law. That's what I'm going to look at. Then he's got a very uncomfortable chapter somewhere, I seem to remember. I'm looking a bit sheepishly at Francois here, so I better be careful. There's a very uncomfortable chapter then on what international law might be. So we have law, returning to Foucault's sketch of liberal society, we have a law which is in liberal and neoliberal societies a rule of law as illimitable and as uninhibited, but a law which in its specific determinate relations can indeed be quite strikingly and at times enduringly limited, such as law in relation to the labour relation, law in relation to the extent to which judicial review will intervene in the prison, for example, or control systems of migration. None of this is a fixed border. The horizon is never there containing law ultimately, but nonetheless you do have quite persistent blocks which, of course, emerge from time to time. Now, all of that leaves me then with a concluding challenge, the challenge of saying or trying to say what the efficacy, what the force of this responsive dimension, which I've obviously been trying to sell, this responsive dimension of law happens to be. This evanescently responsive law which does not seem to have any kind of palpable identity that we can seize on. For Derrida, this is a law which not only remains to come, but remains by coming, ever open to what he calls the coming of the other. He says it deploys the very discourse of events irreducibly to come. It has, he says, no horizon of expectation. It is rather an imperative necessarily present, a response that is ever and already there. So it's coming but there. I mean, the very comingness, if you like, is within the determinacy of what it may be for the time being. It is, Derrida would add, with, I think, a nuanced irony, a force that is a weakness. But a force, he says, capable of making the weakest strongest, and law's insistent illimitability could add point to his concluding that one says to oneself, one knows that in the end, true force is on the side of the oppressed. Thank you.
So we have about 20 minutes for questions. Now, because this is being recorded, I will have to ask you to use one of the microphones, or is there only one microphone? There's only one microphone, so we'll need to act cooperatively and make sure that the flow of questions goes from one side to the other, that you're willing to stand up, rise, and pass on the microphone to the next person.
You'll have to have a sufficiently responsive regard to that imperative.
So be like the law. So, any questions? Okay, Professor Zumbanse.
Thank you. Thank you very much, Professor Fitzpatrick, for your lecture. Allow me to, well, that would be immodest to say invite you, but to maybe ask you whether you could consider what might be the step, the step that would follow an analysis that focuses on these two thinkers, especially in this time and context that we are in now. There's so much talk about, law having to incorporate views from other sciences and to unfold in a much more enriched and contextual discourse. Mm-hmm. And so political philosophy and philosophy as such, of course, are important contenders, but there's so much horrible talk about law just having to become interdisciplinary that right now politics is really difficult to locate in legal discourse. So some people do this kind of work, but many others just think it's enough to deal with law having gone transnational or having gone global by making it interdisciplinary. Mm. And one of the great fortes of your lecture just now is to show that that, of course, has always been a challenge for law and has always been the only way to think of law as law in context. Mm. But now, even after this financial crisis, there is so little of that really done, and if it's done, it remains, confined to a very small set of both scholars, but also of discourses, and so much of that is done in international law. Mm-hmm. But one wonders really where we might find opportunities to build bridges between those scholars that worry about law, how it transcends the nation state or municipal law, mm-hmm. and the law of the economy, because the law of the economy, and that's where you started off with, that just proceeds untouched, right? A lot of this discourse continues as if nothing has ever happened, as if there had been no real globalization, if there had been no end of history, or a contestation thereof, or no financial crisis.
In an immediate kind of sense, I guess I would say law is political. That very kind of contention that I'm talking about is inextinguishably political. But in a kind of an applied way, if you look at the eliminability of law, if one accepts that, then whenever, and you blowing the dust off that first talk I gave at Osgood sort of reminded me of this, actually, so thanks very much for providing an answer to your question, was that law kept coming up against these kind of, seemingly systematic constraints in relation to the labour relation and so on, and there are various other instances I gave, which thank you for reminding me of. That's a politics, law's not comfortable there, and people keep challenging it all the time, and keep challenging that particular division of an arrogation of a particular type of power. Another instance of law's, divine dissatisfaction, if you like, would be the persistent, inextinguishable irresolution between law and sovereignty. This is something that under the late and unlamented, reign of George W. Bush was coming up all the time. The claim to sovereign power and the counterclaim, if you like, all the time in relation to law. Neither ultimately could win because law can't be constrained and sovereignty can't be constrained. So laws, even though, it is incapable of maintaining an enduring content of its own in some in place determinative way, it is always in a position where it's incipiently disruptive of anything that's there. So the resistant ability of law, and this is what I take Derrida to be talking about in the sense on the side of the weakest, at least incipiently and potentially, is always there. So I think that would flow on from it. But one other thing I think would flow on would be by countering the arrogations of, say, sovereignty or modern notions of society itself, and by challenging the completeness of the claims made for them, both conceptually and existentially, you have the question, well, okay, if we set that on one side, what do we do now? And this relates to, I know, other discussions that we've had, but what we are then faced with is the challenge of being with as part of being, and which law would, in that sense, drive us to. And of course, so much else would flow from that, of course. Yeah.
Yes, just a second, Professor Honorary. Thank you very much. Professor Honorary, here. Thank you.
Thank you so much, Professor Fitzpatrick. This lecture was just a reminder of the fantasies I had before going to law school, that you get to hear lectures that talk about everything. I guess I wanted to, and this might be just a small verbal quarrel about hospitality itself, but it seems to me that that word in and of itself, the very fact that now in Derrida is changing from conditional to unconditional, not in a naive way, but in a visionary way, in a way to say that unconditionality cannot be inherently, just can't be unconditional. It depends on the conditions.
Yeah.
But I guess the word itself, the connotation of hospitality, is something to the effect that something must have originated before something else, which is fine from a historical point of view, but since we are now talking across different domains of not just law, my law and your law, but also law and different disciplines,
Yeah.
how would it work? It would be my law receptive to your anthropology, my anthropology being receptive to your law. Which one should precede, not historically, but ontologically, which one should precede the other one? And how does it work? Do you think that actually may not possibly jeopardize the concept of hospitality? It's not the concept of reception and the possibility of reciprocity in some way.
Mm. Wow. I think that the scene or scenario which Derrida sketches there is incompatible with being original and with a claim to the origin, and hence a claim to some surpassing point of initiation. Or if you wish to adopt such a claim, you would have to show that it's already dependent on much that came before it, and to sustain it, you're dependent on much that came after it. In other words, it's impossible to have a monadic or complete claim to the origin. That being so, if one accepts that, then the hospitality would fit into that scheme of things where you might have competing claims, but you could not say that one was prior to another. Perhaps there might be a kind of basic chronological way in which you could, as you're saying, historically point to something coming before another. But in terms of, our being with each other, or being in common rather than common being, in those terms, and looking at hospitality and the law of hospitality and hospitality as law, it would not be possible in a sense. You could not, as it were, elevate one above the other. Now, I guess one would then ask, I don't want to ask myself this, but I have to, now that you've pushed me to it, where does the question of judgment, the question of ethics, and so on come into that? Well, it just comes in, I think. I mean, it's not a relativism. It's not an unlimited so-called, the horrible word tolerance. Anything goes. It's still tough, decisions having to be made on a comparative basis before you affirm your own determinate position. So there is a going out, but there's also a coming from. And in the coming from, those notions of judgment, evaluation, the formative force of them would come into play, I think.
Michael Poon.
Thanks, Professor. Just a question, I guess, from the student perspective.
Yeah.
It's about the study of law and also law and society or socio-legal studies here at York. And my question is focused on both the learning and teaching of norms, if you will, very broadly. I'm just thinking that given your talk about issues of God, relations between law and society, is law just society? Obviously, I think your answer is no, but as a practical level for students and also those who teach students, are there maybe a few pointers or directions you think that after having kind of thought about these issues, thought about the relationships that we could advance or more productively teach and learn about norms, about law? Because sometimes you hear from like judges and practitioners, let's have something useful for what I do come out of a law school.
Yeah.
Or you
Yeah.
hear people saying that, well, in my discipline, law is viewed strictly from disciplinary focus, and the guts of what actually happens there, we're not really concerned about. Like, we're just studying strictly from sociology or anthropology. What kind of directions or pointers would you think would help us do our learning and teaching better in that area?
One, abolish legal positivism.
Ouch.
I've done it now. Two, have a much more questioning regard, to put it mildly, to the disciplinary, conceptual boundaries that are erected around the subjects one is teaching, and around the contents inside them. Of course, one can't simply just dissolve them, and that they are an insistent and persistent reality in their own right, so to speak. But there is more of a dynamism to them, and it would open up things rather more effectively. I mean, over lunch, for example, we were talking about the way in which law schools here are sort of responding to various changes going on, and how that's having an effect on the curriculum and on what's taught and all the rest of it. And I was asked, does the fact that the UK is a member of a kind of this thing called the European Community, does that have any impact on the curriculum, on what's taught? Which one would think it would, because the EC law is just so extensive and touches every area that we have anything to do with in a law school. And with one exception, which would be constitutional law, I had to say, I wasn't embarrassed, I was quite enjoying it. No, it's madness, madness. And so it would, by posing connections, you would then have to say, well, what are we connecting with, So if we're talking about, something in a subject like in a teaching tort or something, you're talking about product liability, and the standards that the EC insists on, and I'm very grateful to it, are so much higher than standards which they displaced within the UK itself. The food industry gets very upset about it, but it's very difficult to pay off the EC. It's much easier doing it internally, as it were. That to me would be a relevant factor, and it would connect that law more closely with EC law, and would be, practically speaking, I've got there at last, practically speaking, it would amount to, you'd be producing better lawyers.
Professor Buchanan.
Thank you, Professor Fitzpatrick, for a lovely talk, and I know I'll be having my aha moments many years hence, as that's been my experience. But I did admire in particular the way in which the talk, that begins with sort of the tentacular reach of neoliberalism and governmentality, sort of led us inexorably to the opposite conclusion of where I thought we were going to go, which is that the law is on the side of the oppressed. And so my question is about trying to explore the counterintuitive aspect of your conclusion. And I guess I'm wondering, is it the case then that modern law, in your view, must also be inclusive or encompassing of other conceptions of law or other legal orders, including indigenous legal orders, such as those that would be pre-existent in Canada, and that this is referring to other conversations we've obviously had earlier this week. And I was mindful in particular of sort of the example of hospitality that we saw in the film The Journals of Knut Rasmussen, which is the hospitality displayed by the Inuit community to the visiting explorers and the implications of them.
There's when I first read the Derrida, his little book on hospitality, I said, no, hang on, he's got the wrong society, that's the Bedouin, you know what I mean? So, but no, it would, and this, might be, going back to Michael's question, it might be a bit too, dissipating, but if you adopted that approach to law, you could not avoid seeing just taking the indigenous law or laws as an instance, you could not avoid the interactivity, if you like, between those two things in which each side of the equation is constituted. Now, one might say, in a fairly confident critical or Marxist way or something like that, oh yes, we've got to see the interaction to see what that so-called dominant legal system did to those other systems and the horrifying things they did with them. But you cannot understand that until you start to try and see what the effect of the indigenous system would be if it were allowed, a more effective interrelation with the so-called dominant system. You can only really get to grips with what that effect is once you see how the other one should change as well. So I think a lot of critical work, which of course is wonderful, but I think a lot of it just assumes the dominance of those systems. It would for a start. Kirsten Anker at McGill does wonderful work like this, I think, where she draws out of the indigenous societies profound philosophical points about our inability just to be by ourselves, and with Nancy's poignant phrase, we cannot be alone being alone. And so much of indigenous relation, well, what a horrible word, but it's floating around a lot these days, relationality, say particularly, I know some Australian stuff which is very strong on this, involves segmentary societies and so on, seeing themselves as absolutely, dependently related to other societies, even if they're considered to be their enemy in some way. Paul and I were discussing the Orenda, Joseph Boyden's novel over lunch, and some of the ways in which these people see themselves being the same, I won't go into detail, of course it's just after lunch, but are pretty horrifying, which are then seen as rather barbaric kind of practices or savage practices, and which he shouldn't be writing about in Canada in this day and age and all the rest of it. But that betrays a lack of understanding of what those things were. So the other side, as it were, has to get a grip as well if there's going to be a kind of a transformative practice linking those two different kinds of society. But I'd extend that to all sorts of other relations as well.
Other questions? Anyone? Professor Baba.
Thank you for a very interesting talk. It sounds to me like you're kind of passing on the question of where does law come from, and you're not necessarily focusing on that as much as focusing on the question of what does law do and how does it move, and what are its products and what are its possibilities. I'm wondering, is it that the question of who is the lawgiver is no longer relevant or is not of interest to you? Is it something we should be interested in? Is it a worthy question to pursue, or ought we to simply focus on what happens when law is thrown into the mix, as it were?
Yeah, spot on, Faisal. Yeah, I think, given my emphasis, you could say it doesn't come from anywhere, couldn't you? Because particularly with Rousseau's lawgiver, it's got to be everything's de novo, isn't it? Because he's not connected to anything really, in a way, and it's just the result of his giving that then gets brought to bear. But I think, if one looks at the other side, if you like, at the determinate side, the determined, if you like, the effective side, there has to be a history. I think, this is a bit silly, but I think it goes both ways. And I'm stealing from Derrida here in Before the Law. Law can't have a history because it's capable, always capable of vacating itself completely, and its content is always disappearing from it, as it were. So he says quite bluntly that law doesn't have a history. But then he talks a bit later on about the whole history of law. Now, one thing about Derrida, whether you like him or not, he's never inconsistent. So you have to ask yourself, what in the hell does he mean? And you realize, yes, okay, it doesn't have a history in any kind of settled sense. It's always becoming other than what it is, but it's coming from somewhere. There is still a history in that sense. So you wouldn't be able to just sort of stand up in court and make up a rule of tort, which suited your client or something like that. Of course, there would be precedent to be contended with, to be struggled with, to try and stretch this way, to push that way in the direction of its responsiveness. But you would always start off with something, well, not always actually, but anyway, start off with something. There would be degrees of creativity. I mean, transitional justice, as we were touching on yesterday a bit, in some societies is incredibly inventive, all sorts of things are put together from all over the world in ways that I don't think anyone could predict and see as any kind of a coherent continuing history. And I certainly wouldn't like to be tried under a lot of regimes of transitional justice, because you take a bit of stuff from the ICJ here, and you take a bit from Truth and Reconciliation in South Africa there, you take a bit from your internal constitution, you mix well, and then bake. It's pretty wild stuff. So I think there are degrees, aren't there? And I think these degrees probably vary in terms of our own feelings of our own imperatives in regard to security and expectation and so on. Yeah.
Okay, well, it's always difficult to close after such an ambitious presentation that animates the fantasies of some of our colleagues, wishes the death of some schools of thought that people like me at least partly adhere to. But this being said, I think we're all very thankful to Professor Fitzpatrick for yet a fourth visit to Osgood and really thoughtful presentation. And the challenge when somebody has come to 4 times to Osgood is to make sure that our token of appreciation is not the same as the one that we've offered on past trips. So here I'm going to cross my fingers because unfortunately I was not there for those previous visits. Yeah. Thank you very much for a very thoughtful presentation.
Thank you. Thank you very much. Thank you. Thank you.